Hey out there, legal warriors. In this video, I'm going to cover what I like to call the twilight zone. The situation where somebody that you know or love, or maybe yourself, you get arrested for a crime or investigated for a crime and you don't know what's going to happen next. It's very confusing. I've been training new attorneys and my staff on this, and I have a new way of thinking about it, so I'm going to share it in this video. So stay tuned if you're interested in this area of the law. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington state for more than 20 years. And I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people will get the help they need. I'm just going to jump right into it. As I said, I've got some really great attorneys starting at my firm, and I've been having to train them about how to figure out when court is going to be, what's going to happen when someone gets arrested or investigated for a crime. And, you know, I've been doing this 30 years, so it's second nature to me. But people that are looking to get some help from an attorney, the loved ones dealing with someone who's been arrested, someone who's been investigated for a crime, they really are so confused when they call on us. So I've thought of a new way to try to describe it. And so what I want to do is describe physically what happens to give a court jurisdiction to do things for somebody accused of a crime, either arrested for investigation of a crime, which means no criminal complaint filed yet, or officially charged with the crime by a criminal complaint, either from an officer, if they're allowed to file their own complaint, or from a prosecutor who files a criminal complaint in court. So first of all, what do I mean by a criminal complaint? The charging document that officially initiates criminal proceedings against somebody. I hereby accuse John Smith of domestic violence, assault in the 4th degree for having intentional, unwanted contact with Mrs. Jill Smith on September 1st, 2022 in the city limits of Seattle, against the peace and dignity of the people of the state of Washington and statute RCW such and such, signed by Prosecutor, Mr. or Mrs. Prosecutor. Okay, and so that's a complaint. And so let's talk about a situation where a complaint isn't filed yet. Somebody gets arrested for a crime. Who does the arrest? Right? A police officer investigates a crime. Let's say it's an assault case. They get a 911 call, they show up, they talk to the parties involved, and they arrest, in this case, let's say they arrest Mrs. Jones. Mrs. Jones gets handcuffed and they get taken to a jail. Which jail will they get taken to? Well, it depends on the physical geography, the jurisdiction where the arrest was made. So in this case, let's say it's in an unincorporated area in Snohomish County, right? It's not within the city limits, so a sheriff shows up, arrests Miss Jones. Where are they going to take her? Well, they're going to take her to Snohomish County Jail. If it's in a city and the city doesn't have a jail, they're going to contract with the jail to hold their prisoners. So you'll want to talk to an attorney. You know, like the city of Bothell uses Snohomish County Jail. Some other cities farther south will use SCORE, which is down by the airport. There's all types of different jails. Some cities have their own jail. Kirkland has its own jail. Linwood, except for the rebuilding right now, has its own jail. But getting back to Mrs. Jones, they're going to take her to Snohomish County Jail. So what happens when Mrs. Jones gets there? Well, in this case, the jail staff will book Miss Jones into the jail, and they need some paperwork from the police officer. The paperwork is what we're going to call a probable cause statement. It can be called other things like a super form, but a probable cause statement is a short statement, a summary of the facts that justify the officer's decision to arrest Mrs. Jones. And so the officer will give that paperwork to the jail, and then the jail will somehow get it to the court's attention. And what gives the court jurisdiction over Mrs. Jones is the probable cause statement by the police officer accusing Mrs. Jones of violating that assault law. So what happens next? Well, at some point, the next morning, if it's a normal weekday, if the weekend happened, it might not be until Monday, right? Depending when the arrest is. A court clerk is going to come in and enter that paperwork. Typically, somebody from the court will enter that into the computer and get it on a court calendar. Court calendar is a listing of the people that need to be heard by the judge, because there's certain court rules that say that Mrs. Jones needs to have her case heard, and she either needs to be released or have bail set so she can post bail to get out, or there needs to be a no contact order, stuff like that. So there's going to be a list, and the prosecutor is going to get that list of the people that are going to be heard on the next available court calendar. There's going to be a public defender that gets that list, and then the jail is going to get instructed to bring Mrs. Jones to the hearing where the court's going to decide to release her or not. And there's a whole lots of different ways that it works. There could be a paper court without Mrs. Jones there. You need to talk to an attorney about your local jurisdiction. But what I want you to understand is that what gives the court authority to act in that case is the probable cause statement accusing Mrs. Jones of a crime. Now, the court has limited authority to act if there's not an actual criminal complaint filed. Under the court rules, the judge can only exercise authority over Mrs. Jones, who's arrested but not yet charged by a complaint, for 3 court days. If there's not a criminal complaint filed by someone who's authorized to, in this case a prosecutor, within 3 court days, all the jurisdiction, the power of the court over Mrs. Jones evaporates. They have no power, and she must be released without conditions. That's in the court rules. So in a case when someone's arrested where the officer does not file their own complaint, what gives the court authority to act is that probable cause statement, and their limited authority, a limited time, because of the court rules. So that'll sort of help you figure it out. Well, Lance, how do I know whether or not the officer has authority to file their own criminal complaint? You can't know for sure, but I've covered this in other videos. The best rule of thumb is that police officers that work for a municipality, what do I mean by that? A city, that are in the city limits of a place, Edmond, Seattle, Shoreline, different places like that. It could be farther south, Tacoma, SeaTac, you name it. For the most part, those officers are allowed, for the most part, to file their own criminal complaint into court if it's not a felony. If it's a felony, no officers can file their own criminal complaint. They can only arrest on probable cause, file their probable cause statement, and that judge only has authority for 3 court days. So what about the situation then when the officer does have authority to file their own complaint? What happens physically then? Well, what happens is the officer nowadays, for the most part, fills something out, this really complicated piece of paper that looks like a traffic ticket, except for state patrols look different. It looks like a traffic ticket, and it accuses someone of a crime. You got to read it really close. But they file this complaint, like I talked about before. They'll take it and they'll file it with the court themselves. So what happens? Well, once the court opens, the court clerk gets the complaint. They're going to enter it in the computer. If the person's arrested and in jail, they're going to probably be heard the next day or so, for the most part, court day. If they're not arrested and in jail, the court's going to send a summons to the defendant to appear at a future court date for arraignment. Once a complaint is filed, then the court has authority over the defendant for a much longer period of time, basically until the case is resolved, or even after it's resolved, because they may have probationary powers. So if the officer files his or her own complaint, then the next court time the court will see somebody is typically called an arraignment, and that starts the proceedings. This 3 court day jurisdiction limit thing does not apply. So when the officer files their own complaint, the court's authority is based upon that complaint and is much broader than a probable cause arrest only. So what's the other way that the court can get authority if the officer doesn't file their own complaint and the officer hasn't arrested and only filed a PC statement? Well, it can be when the prosecutor files a complaint. So in those cases where the officer just refers the case to prosecution and doesn't arrest someone, or doesn't have the power to charge them themselves, they send a report to the prosecutor. That's one situation. Or the other situation is when someone got arrested and they are let out of jail because there was no complaint filed within 3 court days. Well, Now, the prosecutor has a file in their office that's a police report, because the police did the investigation, suggested a certain person get charged with a crime. Now, the prosecutor reads the reports and makes their own decision, should I charge this person with a crime or not? And if they do decide to charge that person with a crime, what happens? Well, someone in their office fills out that criminal complaint accusing Mrs. Jones here of a crime. They filed it in the court. The court clerk enters it into the computer system. The court then issues a summons telling Mrs. Jones to come to court. They mail it to Mrs. Jones and they tell her, you need to come to court on a certain date and a certain time and a certain court to get arraigned. So why have I gone through all this? I know it's confusing. But why I've done this is because so often those of us that have no experience with the system have no idea what's going to happen when someone gets arrested. And this will give you some idea of a guideline. What you need to do is call an attorney and know sort of who arrested, what jurisdiction, know what type of crime you think it is, and know the proper name and date of birth of the person, and let the attorneys figure it out. We actually keep a chart that I'm adding to all the time of when court cases are likely to be heard. You know, if somebody gets arrested in Bothell for a DV assault 4, which is a common arrest, I know they're probably going to get heard at a certain time the next morning. I know that it's going to work a certain way. If it happens in Edmonds, it's going to work another way. If it happens in SeaTac, it's going to work another way. Similarly, if there's a felony arrest in King County, it works one way. In Snohomish County, it works a totally different way. So you can't know everything, but now you can have some idea physically of what happens to get an idea. Is my loved one charged yet? Is there, how long can the court have jurisdiction on them? Stuff like that. So I just wanted to go over that, and you know, this still may not have made it too clear, but if you pay attention to what we've been over here, you'll have a better understanding of what works and how to navigate the twilight zone. So if you find this useful, please like and please subscribe. More people get the help they need, and more importantly, if you've got a criminal case, if someone just got arrested, or you have a case going on, feel free to reach out to my firm. We're in Washington State. We'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.